Welcome to the audiovisual program, Classified Collective Bargaining Agreement 2023 through 2026, between the Greater Albany Public School District 8J and Greater Albany Association of Classified Employees. This is Article 32, Grievance Procedure. 32.1. It is the intent of this article to provide a process for resolving alleged grievances involving members of the Classified Bargaining Unit of the Greater Albany Public School District 8J. 32.2. Definitions. Employee. Any member of the bargaining unit of which GA-ACE is the exclusive bargaining agent. Grievance. A claim by an employee, group of employees, or the association based on interpretation, application, or violation of this agreement. Aggrieved. The employee, the group of employees, or the association who is presenting the alleged grievance. If the association files a grievance for the employee or group of employees, the employee or employees shall be named. However, on an individual grievance, the employee must follow Level 1, informal step of the grievance procedure. Involved. Prior to the association's filing a group grievance, at least one representative aggrieved employee must have proceeded through Level 1, informal. Supervisor. A person who is responsible for the supervision of the employees on whose behalf the alleged grievance has been filed. School day. A working day for the employee except when a grievance process is not completed by the end of the aggrieved's work year. In that event, school days shall mean Monday through Friday. Representatives. A person or persons who may speak for and/or advise the aggrieved. Association. Greater Albany Association of Classified Employees. 32.3. General Provisions. A. There shall be no restraint, interference, discrimination, or reprisal exerted on any employee choosing to use, or to refrain from using, this procedure for resolution of grievances, nor shall there by any restraint, interference, discrimination, or reprisal exerted on any witness or others who might be a party to, or contribute to, the solution. B. Failure at any level of this procedure by the aggrieved to appeal a grievance to the next level within the specified time limits shall constitute acceptance of the decision rendered at that former level. C. Failure at any level of this procedure to communicate a decision in writing acceptable to the aggrieved within the specified time limits shall permit the aggrieved to proceed to the next level. D. The processing of grievances shall not interfere with the aggrieved's regular work responsibilities. E. Hearings shall be considered closed unless the parties agree otherwise. F. The aggrieved shall have the right to association representation at all levels. G. The parties will, upon request, provide any reasonable factual information relating to the grievance. H. All documents, communication, and records dealing with the processing of grievances shall be filed separately from the personnel file of the aggrieved. 32.4. Levels of Procedure Level 1. If the aggrieved believes that they have been adversely affected as a result of misinterpretation or misapplication of this agreement, they shall within 20 school days of the active time, they first had knowledge or reasonably should have had knowledge of such problem, whichever is later, do the following. A. Discuss the matter with their supervisor with the objective of resolving the matter informally. B. If the problem has not been resolved informally, the aggrieved may file the grievance in writing with the principal or supervisor who has the authority to resolve the grievance. Such statement shall include the facts and contract articles involved and the remedy requested. Level 2. Superintendent or designee. If the aggrieved is not satisfied with the disposition of the grievance at Level 1, or if no decision has been rendered within 10 school days after the presentation of the grievance, it may be filed within 5 school days with the superintendent of schools or designee for a decision. The superintendent or designee shall be presented with all facts, documents, testimony, etc., pertinent to the specific grievances and have the discretion to arrange a hearing involving all parties. Level 3. Arbitration. If the aggrieved is not satisfied with the decision of the grievance at Level 2, or if no decision has been rendered within 10 school days after the grievance was delivered to the superintendent, the aggrieved may request, in writing, that the association submit the grievance to A. The association may submit the grievance to arbitration with a copy to the superintendent within 10 days after receipt of the decision at Level 2. Arbitration, including the selection of an arbitrator, shall be in accordance with the rules and procedures of the American Arbitration Association. The arbitrator shall confer with the representatives of the district and the association and hold hearings promptly, and shall issue the decision not later than 20 days from the date of the close of the hearings, or if oral hearings have been waived, then from the date the final statements and proofs on the issues are submitted. The arbitrator's decision shall be in writing and shall set forth findings of facts, reasoning, and conclusions on the issues submitted. The arbitrator shall be without power or authority to add to, detract from, or in any manner modify the terms of this contract. The decision of the arbitrator shall be submitted to the district and to the association, and shall be final and binding on the parties. The costs of the services of the arbitrator, including per diem expenses, if any, and actual and necessary travel, subsistence expenses, and the cost of the hearing room, shall be borne equally by the district and the association. Any other expenses incurred, including the cost of witnesses, shall be paid by the party incurring same. 32.5. Additions. A. Time periods may be adjusted by mutual consent of the parties involved. B. Year-end grievances. If a grievance is filed at such time that it cannot be processed through all the steps of this grievance procedure by the end of the school year, the time limits set forth herein may be reduced so that the grievance procedure may be exhausted prior to the end of the school year, or as soon thereafter as is practicable. C. No issue whatsoever shall be arbitrated or subject to arbitration unless such issue results from an action or occurrence which takes place following the execution date of this agreement. And no arbitration determination or award shall be made by the arbitrator, which grants any right or relief for any period of time whatsoever, prior to the execution date of this agreement. D. It is specifically and expressly understood and agreed that taking a grievance appeal to arbitration constitutes an election of remedies and a waiver of any and all rights by the appealing party, the labor organization, and all persons it represents to litigate or otherwise contest the appeal subject matter in any court or other available forum. Likewise, litigation or other contest of the subject matter of a grievance in any court or other available form shall constitute agreed waiver of arbitration.